Hello students, welcome to class. Our topic for today is business law. In this class, we'll be looking at the meaning of business law, the branches of commercial law, and the law of contracts. We'll be starting off with the meaning of business law or commercial law. Business law encompasses all the laws that dictate how to form and run a business. This includes all of the laws that govern how to start, buy, manage and close or sell any type of business. Business laws establish the rules that all business should follow. Generally, a business person will be familiar with business laws and know when to seek the advice of a licensed attorney or a lawyer. Business law includes state and federal laws, as well as administrative regulations. Now let's take a look at branches of business or commercial law. Commercial law includes company law, corporate governance, competitive law, that is antitrust. We also have consumer protection, contract law, we have environmental law, we have intellectual property law, we also have copyright law, we have patent law, we also have trademark law, next is international law, and we also have labor law. All these are some of the laws under the umbrella of business or commercial law. Now let's move on to contract or definition of contract. Contract can be defined as an agreement between two or more parties which is intended. Having known the meaning of contract, let's move on to classification of contracts. Contracts can be classified into formal and informal contracts. Under formal contracts, we have contract of deed or specialty contract. This is a kind of formal contract whereby promises are written on a paper, signed, sealed and delivered. The contract is under seal and is carried out by putting a seal on it. They do not usually require consideration. The next type of formal contract we're looking at is contract of records. These are obligations imposed by the court. They are not true contracts, but contracts which are acknowledged before the law courts. While informal contracts are simple contracts which must possess all the essential characteristics of a valid contract. All contracts that do not belong to the formal contract above are referred to as informal contracts, and because of its flexibility, it may be difficult to execute. For example, contract of sales. Now let's move on to essential element of a contract. We have offer and acceptance. For a contract to be valid, there must be an offer made by one party to the other party, and the offer must be unconditionally acceptable. Acceptance must be absolute, and once it is completed, it cannot be revoked. So now let's move on to characteristics of an offer. We have an offer must not be mistaken with the answer to a question or supplying of information. 2. An offer must be communicated to the offeree. 3. An offer may be expressly made or implied by the conduct of the parties. 4. An offer may be made to a specific person or a group of persons. Now let's move on to termination of an offer. An offer can be terminated in the following ways. 1. When the offeree notifies the offeror that he does not wish to accept the offer. 2. Lapse of offer, that is when the time of the offer has passed. 3. Withdrawal or revocation of the offer by the offeree. And 4. a refusal, or counter offer. These are some of the conditions that may lead to the termination of an offer. Now let's move on to rules of communication of acceptance. These are rules or guidelines for a valid acceptance to be made. 1. The offeree must positively accept the offer. 2. It must be communicated by the offeree or someone with his authority. 3. Acceptance is not effective until communicated to by the offeror and received by the offeree. 4. Acceptance is not effective if communicated in ignorance of the offeror. 5. Intention to create legal relations. It must be clearly stated that the parties intend to create a legally binding contract. There must be no clause that will exclude the court. And 6. There must be valuable consideration. All valid contracts or valuable contracts must be supported by valuable consideration. That is to say that an agreement can become contract when each of the parties give or promises to give something of value to the other party. Next, certitude of terms. The terms of contracts must be clearly stated. The parties can expressly state every terms of their contract. A contract may contain two types of clauses, namely express and implied terms. And lastly, possibility of performance. The parties to a contract can enter into a contract once they are sure that they can do the job. It must be possible to carry out the contract. And before we go, let's take a quick exercise. Question 1. What is the meaning of business law? Question 2. List 10 branches of business law. Question 3. Define contract. Question 4. What is the law of contract? With this, we've come to the end of this lesson. Thank you for watching. See you in our next class. Bye bye.